In this video, I'll explain exactly what to do when your business partner locks you out of your company's bank accounts. And by the end of this video, you'll know how to fight back fast, protect your money, and regain control of your business, even if your partner thinks they're already won. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've seen this exact situation destroy businesses that didn't have to die, and the ones that survived all did the same things in the same order. All right, let's dive in. Here's what's happening right now in your situation. Your partner made a calculated move. I call it the lockout. The lockout is when one partner unilaterally removes the other from the company's bank accounts, payment platforms, or financial systems without a court order, without a legal fight, and without warning. It feels sudden. It feels personal. But the reason it happens is almost always the same. Your partner wants leverage, and they just took it. Now, you're probably thinking, can they really do that? And the answer is, they just did. And it does not mean it's going to stand. But here's the thing most people get wrong at this exact moment. The worst thing you can do after the lockout is nothing. The second worst thing you can do is call the bank and start arguing. The bank did not do anything wrong. The bank changed the signatories because your partner asked them to. Yelling at a branch manager does not get your access back. It only wastes time that you do not have at this point. So stop trying to handle this the way you'd handle a personal banking issue. This is a legal emergency, and the reason it needs to be treated that way is because every day you wait, your partner is operating the business, spending money, and building a paper trail that makes their version of events look legitimate. So here is the Florida Playbook, the exact sequence of moves that actually work. Step 1 is the emergency injunction. In Florida, when a business partner takes unilateral action to damage the company or strip your rights, you can go to court and ask for emergency relief. A judge can issue what's called a temporary restraining order, or TRO, that freezes the company's accounts and prevents either party from moving money until the dispute is resolved. This protects both sides. And the reason you need to move on this within days, not weeks, is because Florida courts look at how quickly you acted. Delay signals to the judge that maybe it was not that urgent after all. Now, I know what you're thinking. What about my operating agreement? Doesn't it protect me? And here's where it gets interesting. Your operating agreement is actually your most powerful weapon, or it could be your biggest problem, depending on what's in it. Step 2 in the Florida Playbook is a full review of your operating agreement before you do anything else. In Florida, operating agreements govern how members of an LLC can be removed from financial access, how decisions are made, and what happens when partners disagree. If your partner violated that agreement, and the lockout almost always does, that is breach of fiduciary duty. That is not just a civil claim. That is the foundation of a strong damages case. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Step 3 is documentation, and stop underestimating this step. I cannot tell you how many clients have come to me with a solid case and weak evidence. You need bank statements, emails, texts, wire transfers, anything that shows the business's financial activity before and after the lockout. You also need proof of your ownership stake, your contributions to the company, and any communications where your partner acknowledged your role. Screenshot everything, download everything, and do it today, not tomorrow, because access to that information can disappear. Now, here's what most people miss about the lockout. It is rarely just a bank account. When a business partner takes this kind of action, they are signaling one of two things. Either they want out or they want you out. Both of those outcomes lead to the same destination, the business divorce. And just like a personal divorce, how you manage it in the first 72 hours determines everything that comes after. Your leverage, your settlement, your share of the business value, all of it starts here. The good news is that Florida law provides real remedies for partners who have been wrongly excluded. Courts take breach of fiduciary duty seriously. And when you move fast and you move smart, the person who used the lockout as a power play often ends up in a much weaker position than when they started. So to recap the Florida Playbook, move immediately to seek emergency court relief. Pull your operating agreement and identify the breach. Document everything you can access right now and retain a Florida business litigation attorney who understands partnership disputes, not just general business law. Your partner made a move. Now you need to make a better one. If you found this video helpful, please like it and subscribe to this channel. I release new videos every week covering exactly these kinds of real-world business law situations that Florida business owners face every single day. And if you're going through this right now, reach out. This is exactly what we do. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.